Good afternoon, everyone, and welcome back to another episode of The Debt Life with me, Chad Van Horn. Today we're going to talk about wedding bells and bankruptcy, expecting the unexpected. And we have some great stories that we're going to talk about. We have some sad stories that we're going to talk about because we know that financial instability is one of the main reasons for divorce. But we're going to talk about how the government actually encourages people not to be married or get a divorce or separated. Before we get into that, I'd like to talk about current events, current topics. Unfortunately, in the last 2 weeks, my family has lost two matriarchs. My great aunt Edith, who would have turned 99 today, and my great aunt Jean out in Washington State. So with a heavy heart, we're doing this today. I wanted to show some pictures of my aunt. This is my aunt Edith. Back in graduation, she actually got to hood me, which was really cool. And this is us dancing when she first came down here. This is back when I first moved down here. So that's a picture of that. So I'm going to be posting more pictures on my personal Facebook today and putting that information out there because I know that she has impacted many people's lives, including mine and my direct immediate family. So let's jump into it. So we know that financial instability causes many issues with marriage. When you're going into marriage, you really should know your spouse's financial situation. You need to know what you're walking into. I know there's talks about prenups and different things, and we're going to talk about how you can become liable for another person's debt and what debt you are not liable for going into it. So let's jump into a hot subject, which seems to be on the news every day right now, student loans. And as I go through this, if you have any questions, make sure you pop them in the chat. I will answer them at the end or as we're going on. So if you have any questions whatsoever, make sure that you ask. So student loans, will you be responsible for your spouse's student loans? The direct answer is no. You're not responsible for your spouse's student loans unless you co-sign on the student loans. So if they had the student loans before you got married, you're not liable for those student loans unless they're refinanced and you put your name on them. In a federal student loan situation, if your spouse passes away, their estate is not liable for that debt, meaning that if there was property and it'd go through probate, the student loans wouldn't come in and make a claim. If they're private student loans, they would. So that's how they still can impact you, even though you're not responsible. The estate could be responsible. So some good estate planning probably can help with that, making sure that you have something called a ladybird deed where property transfers automatically upon passing. That's for real estate, and there's different trusts you can set up and other ways that you can potentially avoid that. Now, the spouse's debt will also not impact your credit, but if you are applying for credit together, if you want to get a mortgage, then it can impact what kind of mortgage you can get because that can impact the debt-to-income ratio, which would lower the credit score. So make sure that going in that you understand their financial situation, and it's good to be honest. I do believe in keeping finances as separate as possible. There was a time where the federal government was allowing married couples to refinance, basically consolidate student loans between spouses. If there is a divorce, it causes a mess because you don't know who's responsible for what. It's really hard to separate those out. When I talked about earlier how the government is actually discouraging marriage or encouraging divorce, student loans is one of the aspects that they're doing it. When it comes to income-based or income-driven repayment plan, and there's multiple versions. There's revised pay-as-you-earn, income-based repayment, income contingent repayment. They actually look at household income. So if your household income is high, if your income is low as a student loan borrower, but your spouse's income is high, they're going to look at the household income and your payment is based on that. So in a way, they're making the spouse liable for those payments. Now, there are ways around it if you keep your finances separate, if you file separate tax returns, and you really don't have access to each other's finances, there's ways around it. But again, that is a way that the government is discouraging marriage or encouraging people to get divorced so that you don't have to be quasi-liable for the student loans. Again, they're not going to report on your credit. You're not actually liable, but when your spouse goes in and does their income-based repayment calculation, they're going to look at your income as well, which means that the government's making you support those student loans. So With regards to private student loans, that's not true. They will not look at your income. They will not take that into consideration. So if there are settlements or negotiations where they're asking for a spouse's income, I just wouldn't provide it because again, you're not liable for it. The only way you're liable is if you signed up for a joint loan or if you refinance those into a loan. So that's with student loans. So if you have any questions on that, feel free to email me, message me. It's really straightforward. With good planning, you can you don't have to get a divorce to get into the income-based repayment program that's right for you, and there are ways to do it properly. You just need to go through and make sure all the paperwork is consistent. Moving on, so another hot topic, credit cards. Probably everybody listening right now has at least one of them in their wallet, if not multiple. So when it comes to credit cards, people get confused of joint accounts, authorized users. What's the difference? So a joint account basically is you're both liable for the debt. I don't actually recommend having joint accounts. I'd recommend instead doing what's called an authorized user. So let's start with joint accounts again. Joint account, you both apply for the debt. They use both of your credit score to get the debt, and you're both fully liable. There's something called jointly and severally liable, meaning that if you default on that credit card, they can collect from either one of you 100%. Now, if you do break up, if you have a joint account, and this just isn't with a spouse, if you have a joint account with anybody and the relationship turns sour, make sure you close that account. Because if you go through a divorce or a bad friendship or a family member or whatever it is, you're actually going to be liable for that account if they ran it up after you got your divorce. And I've seen that happen in the past. So if you have a joint account with somebody that you don't talk to anymore, call the creditor and close out that account immediately, or get yourself off that account. So the advantage to the joint account is, generally speaking, they'll give you a higher limit because there's multiple people. And if your credit's better, they'll give you a higher limit. Disadvantage, they can go after both of you 100% of the time. Also, there's something in Florida and many states called tenancy by the entireties. Anything that you own jointly with your spouse cannot be attached by creditors that are only a creditor of one of you. So if you have a joint account, that means they can go after the assets. So to give you an example, if I own a car with my wife and I personally defaulted on a credit card, they could not go after my car because I owned it jointly with my wife. We acquired it during the marriage, and we each own 100% share of that. Now, jumping into authorized user account, it's very different than a joint account. So the authorized user account basically is exactly as it sounds. I'm giving authorization for somebody else to use my account. I really like the authorized user account because you remain in full control of it. So you can take somebody off immediately without their consent. It actually helps the other person's credit, so that they get the history of the credit line, which it doesn't really make sense to me. But I recommend when people are trying to rebuild their credit, if you have somebody that you can trust, and again, there's a trust thing here because once you give them an authorized user account, they can use that account just like it was yours, run it up, and you're responsible. And they actually are not responsible unless they commit fraud or there's some outlier there. So the authorized user account, I think is much better than a joint account when it comes to spouses, wives, and even relationships like familiar relationships or friends. So if you're looking to do something, that's a better way to go, in my opinion. I see a couple questions coming in. A couple of friends of mine: can a spouse's medical debt be transferred over to me? Great question, Gina. Only if you sign off on it, only if you sign for it, can the medical debt transfer over to you. Again, they can go after the estate if your spouse passes away, but they cannot come after you, and if they do, that wouldn't be right. Lewis, does my spouse have to file too? She only has one credit card with a low balance every month. That's a great question. No, actually, there are you can separate the filings, so you can do an individual. You can do an individual filing. Your spouse doesn't have to file, and they can deal with their own. And we're actually going to jump into bankruptcy here in a second. But before we get there, we're going to talk about mortgages and car loans. When we're talking about mortgages, generally speaking, I recommend, this is one of the debts that I do actually recommend having a joint debt for the mortgage if you can, because it is secured by your property. It's going to help both of your credit rebuild or grow, if you will. And it's good to have both of you on the mortgage, in my opinion, if you can. Now, if only one of you has the good credit, one of you's credit's not that good, then it might be better just to use a person with the higher credit, because it's my understanding that they actually go by the lower credit score when calculating your interest rate. So if there's a big discrepancy between credit scores, you may just want one person to be on the mortgage, and then there is a way where you still could have joint ownership of the property, but only one person qualifies for the promissory note, but both are technically still on the mortgage as well, because that's the security interest. I don't want to go in the weeds on that too much, but basically one person is liable for the debt, and then the mortgage is signed off by both husband and wife, or both spouses, because there's a security interest in real property. So again, when you're co-signing for anything or co-borrowing for anything like a car, remember that your name will go on that car as well. And if it's in an accident, you will get sued. So Florida is different than some other states from what I understand. But if you are the owner of a vehicle that is in an accident, you are liable for any damage that's done. So be very, very careful with that. Make sure you have proper insurance in place if you're doing that, especially if you're doing it for a spouse or a child that's just learning how to drive, because they're obviously more accident prone. So just be very, very careful with that. Now, jumping into it, bankruptcy filing and marriage. Now, this is another way that the government is discouraging marriage or encouraging divorce, however you want to look at it, which actually, if you look at the history of the United States and the government, the posture has been to encourage marriage and give tax breaks and different things if you get married. So it's interesting to see that in 2005, I believe the amendment came through where they take into consideration, again, the household income and household expenses. So when you're filing an individual bankruptcy, so if one spouse, if you listened to my advice and you didn't do joint credit cards, and only one spouse had the issue with debt, that one spouse is allowed to file by themselves, and it will not negatively impact the other spouse's credit. So as long as you don't have joint credit or significant joint credit, then one person can file and it won't negatively impact the other. If you did have a joint credit card, the other spouse, the non-filing spouse, if you will, would have to continue paying on that debt. Also, what's really important in bankruptcy, if you only have one spouse filing and you don't have joint debt, again, anything that you own jointly with your spouse would be exempt by tenancy by the entireties in the state of Florida. And that's a huge exemption that many people don't know about that need to take advantage. If you're buying a car, make sure they do not put the title as or. If you start a bank account, make sure they do not title as or, because that is not tenancy by the entirety. So you got to be careful with that. Make sure it should say tenancy by entireties, or at least it should say and on the title, that anything that you own jointly with your spouse. It can only hurt you. It can't help you to have the or designation. So I don't even know why that's legal. I don't know why that's out there, but it's just a very strange thing. I don't know if that's just Florida or if that's throughout. So going back to bankruptcy. So when you're qualifying for bankruptcy, they actually generally speaking, they'll look at household income and household expenses. The median income for a family size of two is just around $60,000, actually $65,935 to be exact. If your income is above that, and you don't have other exemptions for income, and then we're talking about joint income, that kicks you into what's called a Chapter 13 reorganization versus the Chapter 7 liquidation. Now, there are ways to still qualify if there's mortgage expenses, student loan expenses. If there's other expenses out there, then you can still qualify for the 7. Or if you have other dependents, obviously the median income goes up based on family number. But if your income, joint income, and they look at the last 6 months, the average of your last 6 months combined is above that, even if your income was zero, you still don't qualify for Chapter 7 because the household income is above that. So then you get put into a Chapter 13. And in that scenario, obviously your spouse is becoming liable for the Chapter 13 payments because you don't have the money to pay them because you don't have the income. Now, they aren't legally liable. They don't have to make the payments. But if you don't make the payments, then your Chapter 13 gets dismissed. So, that's a way that technically the government's trying to make the family unit liable for the debt by disqualifying them from different programs. Some will argue that it's fair, though, because you are a team. It's joint debt. It was used for household goods that maybe the spouse benefited from. But obviously, in some scenarios, maybe the spouse didn't get any benefit from it, but now they're still becoming liable for it through the Chapter 13. So there can be significant debate over that. But this is the law as it is today, and it's been that way for almost 2 decades now. So um, if you do have joint debt and if you both need to file, the good thing is there is something called a joint filing. So you can do a Chapter 7 joint filing with your spouse. You do have to be legally married. I have a funny story about that. We had a couple in last week, and actually a couple years ago, the same thing happened where they both needed to file. They've been together for many, many years. I told them that if they got married, it would save them money on filing fees and costs because you can do the credit counseling together, you can do the filing fee together, and you can do the case together. And they ended up deciding to get married to save the cost. So that was pretty cool. After decades of being together, they finally actually pulled the trigger and got married. So I hope that works out for them. I hope it doesn't change anything. And that's happened a couple times. And actually, the opposite has happened, where marriages were on a little rocky anyway, and then they found out that as a couple they could not file Chapter 7 bankruptcy, and that's what they wanted to do. And they decided that the relationship wasn't going to work, and they maintained separate households. They went through the divorce process, and they were able to individually file Chapter 7. So it certainly goes both ways. It's really strange. It's a very strange dynamic that you wouldn't think you'd find in bankruptcy, causing divorces or causing marriages. But we certainly see it, and we see it more often than you would imagine. So again, I recommend keeping your finances as separate as you possibly can in situations with mortgages and whatnot. I think that's a good way to go. But if you can separate everything and then try to go 50-50 on the expenses that you can, depending on your relationship. I mean, every relationship's a little different. So let's see if we have any other questions here. If you have a home and it's in foreclosure and your name is not on the mortgage, do you need to get involved in the case? Well, if you own the home, then for sure. If you live in the home, you'd want to at least monitor it. But if your name's not on the home, you don't live there, it really has nothing to do with you. It's an investment property, then you don't really have to get involved in the case. But if it's the home that you live in, you at least want to monitor to make sure that that you're not going to there's not going to be a sale date, you'll be evicted and whatnot. You know, when it's getting to that scenario, you really want to have a conversation with your spouse and make sure that you're being upfront with it. So obviously, the best way to deal with debt and have a happy marriage is to avoid debt altogether if you can, especially bad debt. I do think there's different categories of good debt versus bad debt. If you're getting low interest mortgages and low interest loans that you're utilizing, I think that's good debt. Utilizing to purchase property and purchase different things, that's good debt. If you're getting these payday loans, that's the worst type of debt. If you're getting credit cards that have a decent interest rate, 10 to 15%, that's not bad. But if you have all these loans with 29.99%, I saw a loan that came through was one of those payday loans that had a 250% interest rate. Just avoid those, because that's just really, you're just burning money. You're just wasting money by paying that much in interest. So as always, if you want to get in touch with me, we do free consultations. Call the office at 954-637-0000. You can go to vanhornlawgroup.com. We're now actually open 7 days a week, so I'm doing consultations 7 days a week. We have 3 books, as you can see here. One is named The Debt Life. The other just explains the bankruptcy process. And thanks again for joining me this episode. I hope the topic was timely and helpful for you. Don't forget to like us on Facebook or Instagram or whatever you follow. I think we're on TikTok now too. Artillis is dancing out there. We'll be back in about 2 weeks for The Debt Life. And most importantly, happy birthday, Aunt Edith. Thank you, guys.